Hello and welcome to the ICT Pulse podcast. I'm Michelle Marius, your host and the editor and publisher of ICT Pulse, the online platform where we discuss ICT issues from a Caribbean perspective. In this episode, we'll be discussing intellectual property protection, IPP, a term I'm sure which we have all heard before and to some degrees know what it means, but we really don't know whether it should matter to us. This posture seems to be also true in the Caribbean tech space, where people are developing brands and new innovative products and services. So to help us to get a better understanding of the world of intellectual property protection, we're delighted to have once again Grace Lindo, an attorney at law and a partner at Nunes Schofield de Leon and Company, one of the largest law firms in Jamaica. At NDSCO, Grace heads the firm's intellectual property practice group, so she's excellently placed to give us a primer on IPP, which should be important to the Caribbean tech community. Enjoy. Grace, thanks for joining us and welcome back to the podcast.
Thank you for having me.
Okay, so Grace, let's just jump right in and probably first help us to understand some of the key terms of which we should be aware in any discussion on intellectual property protection.
So intellectual property protection protects the intangibles. And I just want to give a slight background as to where the world is going with intangibles. We are used to, in years gone by, having property mainly in things that we can touch and feel. And for instance, real property and in other assets, jewelry, etc. But now we're moving into products of the mind being intellectual property. And because people want to use those products of the mind as property for the creation of capital so that they can, whether borrow funds based on that capital, based on that property, or otherwise just use that property in the same manner they would use land. We have now designated those types of intangibles with property rights. And it's very important to remember that we didn't always give property rights to intellectual property. And in the tech age, it would be more important for us to designate those property rights because a lot of the creations that we have now are going to be of the intellectual kind. Intellectual property protection is important because we need to, just as we have a register for land and we need to know who owns whatever land there is, you need to know who owns the property because it's actually someone's investment and they need their investment to be protected. They need their creativity to be protected. So it's a growing area and an area in which I think we're going to see a lot more exponential growth in the next couple of years.
Excellent. So let's just begin to talk about what obtains in the region as it pertains to how eager people might be or whether the extent to which they're aware of whether or not they should probably seek a patent or copyright, trademark, or those sort of elements with respect to intellectual property. What has been your sense as to whether we are taking advantage of those protections that are available?
Okay, well, I made the distinction between being aware of the presence of these areas of law for protection and taking advantage. And I think generally people are becoming more aware that this is something that they have rights to. In fact, people sometimes go overboard in thinking that they have rights to their ideas. But generally, you find Caribbean people are, yes, that's my creation. I came up with this design. It was mine. And people are very proprietary when it comes to thinking that this is theirs. We move, however, to whether they make the final steps in vesting their rights, which is what we call when you claim your property rights. Do they vest their rights often? Not as much as we'd like to see. I can speak for Jamaica and say that trademark registrations, for instance, have gone up significantly. We're now 50-50 to international trademark applications. And of course, just to backtrack, trademarks cover brands protected within the jurisdiction. So it could be brands in the form of a logo. Brands can now be in the form of both a word mark and a design mark. It can be a design, which is purely design or just words. But brands can also be sounds and shapes now. So you find a lot more Jamaicans are walking into Jaipur or getting local counsel and trying to protect their brand. It's becoming a very fun thing to do, a very topical thing to do.
Okay. Now, you had mentioned that we seem to at least recognize that we may have something to protect sometimes. I mean, that people might recognize that this is their creation and they would want to protect it. But I have found in the past that they might be more eager for you to sign something like a non-disclosure agreement than to probably seek to, copyright or trademark something. Can you just share with me your thoughts on that, and probably also explain to our listeners what's the difference between trying to get an individual to sign a non-disclosure agreement, or what are the differences between a non-disclosure agreement and seeking to protect your creation via various intellectual property measures as might be applicable?
Okay, so a non-disclosure agreement is something that tries to keep, it's an agreement between parties which tries to keep a particular idea or a statement or a fact, actually, confidential between the parties. And it just means that both parties agree that they won't disclose it to a third party. There may be exceptions, but that's generally what it means. In the IP field, non-disclosures are used when people have ideas. It may not even reach the level or the threshold of being something protected by intellectual property laws. But non-disclosure agreements are used when people have some sort of proprietary idea. It may be a business idea, which may not even get intellectual property protection down the road. It may just be a general idea that you want to come up with a fresh type of businesses in this area, which has no IP attached to it. You can use an NDA for that. In the IP field, people use it a lot for products and product development. Not so much trademarks per se, unless you're trying to get, funding and you want to tell people about your brand. But really, in terms of product development, when you have something that can be patentable or patentable, or something which is like software, if you have software which is unique and you want to make sure that your proprietary rights are protected, even if you have gone through the process of vesting the intellectual property rights in you or in that creation, there is still value in a non-disclosure agreement because it really provides a different sort of service. It really serves a different purpose, rather, because it makes sure that the public doesn't know about it. And people shouldn't confuse the two, because one is to enable further commercial exploration, which is the NDA, whereas intellectual property protection and vesting is one to make sure, yes, you can get commercial exploitation too, but it's also to make sure that people worldwide or within the country get notice of your IP. So it's notice that you're putting out that, yes, you have this IP and you intend to protect it.
Understood. And you had just mentioned about the threshold to be eligible or to meet the criteria for a matter and for an idea or whatever to be subject to intellectual property protection. But can you give us a better sense as to what that might be?
Okay, so the various types of intellectual property, whether it is a patent or copyright or even trademark, those laws are all governed by statute. We do have case law which would interpret it, but they're primarily creatures of statute. And those laws will indicate to us what we considered patentable or we considered trademarkable, for want of a better term. So, for instance, under Jamaican laws, and I make this reference specific to Jamaica and perhaps the Caribbean too, business processes are not patentable. So you can't have a computer process which does something per se being patentable in Jamaica. And you can't have an animal genetic reengineering or anything of that sort being patentable here. But you can have drugs being patentable in Jamaica. You can apply for a patent in respect of a machine that you have created. In the US, from my understanding, as an external attorney, they have laws in relation to mini patents or what they know how they have different levels and types of patents that you may have. You'd call utility models, I believe, that you may have the ability to patent. We don't necessarily have that in Jamaica. So every statute has a threshold, has a test that you must fulfill. In respect of trademarks, it must be something that, one, not every other trader is entitled to. So you can't have someone applying for a trademark called patty, because a patty is a product. It's a type of product, and everybody who trades in patties should be able to use it. Mm-hmm. And when you apply and you get trademark rights, you're saying that nobody else should be able to use your mark. In terms of copyright, there are rules under the Copyright Act too in terms of what is copyrightable. What's the level of creativity that you need to get some copyrightable material being protected? So there isn't a free-for-all in IP. there are always tests, and it's important for people to know what those tests are, because sometimes people go astray in thinking they have actual brands when they do not, in thinking they have actual copyrighted material when it is not.
Definitely. I have a couple of questions based on what you've said so far. And that would be, first one would be, in respect of our MSME segment, whereby these may be people who might be the most creative, the most innovative, as they say, necessity is the mother of invention, but they may not necessarily have the resources to probably completely delegate an intellectual property research and preparation exercise to a third party.
Mm-hmm.
How or what do you think they might be able to do on their own to at least get the process going? Certainly, even if it's to do an assessment as to whether or not what they have is patentable, or could be receive a copyright or trademark before it probably may have to be. They may have to bring in a third party, such as an attorney to help them to complete the process.
Well, certainly in Jamaica, our Intellectual Property Office's website, jaipo.gov.jm, provides a very good summary of each type of intellectual property. And they go beyond patents, copyright, and trademarks. They go to indicate geographical indications, industrial designs, or designs rather. They really go in depth and tell you what each type of intellectual property covers. And so that's a very good starting point. I do believe that even the overseas, IPO websites, I have never been onto, for instance, the Trinidad or the OECS websites, but certainly even the UK intellectual property website, they go very in depth in terms of what different types of intellectual property rights there are. And so I would implore anybody to start there if it is that they don't want to involve a third party, but they want to do their own research, because that's information coming out of the registry itself. No, not all intellectual property rights are registrable. For instance, copyright is created upon the date of creation. So the day that you create your song, copyright vests in you. And technically speaking, you don't need to do anything more. I mean, there is what we call the poor man system of registration, where you put it in an envelope and you send it to yourself. But people have been warning against that, just because there are independent registries out there. So JIPA has now a digital registry where you can submit your work and you can have it stored. And there's a couple of other registries too, which are voluntary registries. So I would implore anybody to, well, if they don't want to get immediate advice, to do their own independent research. I mean, we're in the information age. See what is possibly protected or could be protected, and see, even if it's not possibly protected, like an idea, which I said is not protected, see what sort of arrangement they can make with other persons before disclosing it. Disclosure can be to the detriment of anybody who owns intellectual property.
Understood. And you initially started off by talking about or mentioning the whole issue of intellectual property almost having monetary value, and I guess getting to the point where it can be, for all intents and purposes, collateralized. For example, banks and lending institutions might be prepared to accept intellectual property as security for loans, etc. Can you just give us, some better insight into that, as well as whether or not, or the extent to which those sorts of measures are already accepted in the Caribbean?
You mean intellectual property measures?
Well, yes, but more that it being seen as having tangible value, or being recognized as something that individuals can leverage.
Yeah, I mean, there's that difficulty still in the Caribbean. We very recently, when I say recently, I mean within the last 4 or so years or 5 years, we implemented a security interest in personal property law in Jamaica, which allows people to use their intellectual property and even their artwork to use it as collateral to get capital. So that's a step in the right direction. It really is something that I know is the Exim Bank and I know the development banks are trying to encourage. Again, because as I started out, I mentioned that, capital as we go on is going to be more digitally based, and not even digitally based, but very soft and intangible. So we have to encourage people who don't have access to land, etc., to build upon whatever capital they have. And to build upon on capital, it means you have to really invest that initial capital in yourself. And as you rightly said, get recognition. So it's a slow process, and it will take some time.
Well, definitely. And I'm surprised to hear about that piece of legislation already in existence in Jamaica. But as you said, it probably has not really gotten much traction, at least certainly not mainstream as yet. And I would surmise that it may not be much better across the region.
Right.
Okay, so let's just pivot again. And I wanted to just touch on the Madrid Protocol. What is it and why is it important?
So the Madrid Protocol is really a treaty, comes out of a treaty which is being pushed by the World Intellectual Property Organization, which is trying to centralize trademark registration around the world. Right now, albeit that most countries follow what we call the Paris Convention when it comes to trademark applications. And so our trademark laws worldwide are largely within the same framework with a few details changed. So, one or two countries may have different ways of doing things, different ways of registering in classes, and, but for the most part, we follow the same international system. So it's very harmonized. The Madrid Protocol is a treaty which is being pushed by the World Intellectual Property Office in an attempt to centralize trademark registration around the world, really for the benefit of large companies or really large applicants, which have quite a substantial number of applications. So you may have one company coming out with a product, think of Apple, for instance, and they may need to do 150 applications worldwide. It benefits a country like that if it is able to, if its jurisdiction is a party to the Madrid Protocol, to do one central application and have the application go through an electronic system via WIPO, and WIPO then sends it to the national office. So WIPO would send the application to JIPO. Now, as it happens, Jamaica is not a party to the Madrid Protocol, and I don't think any other Caribbean countries, save and except for Antigua,
Yes.
Antigua is a party. And we have not really taken it up as yet for several reasons. One of the reasons is, even though we have one or two multinationals here, the real benefit is for countries which have large number of multinationals. And so we are really an importer of Madrid Protocol applications. It really would not be to the benefit of many Jamaican companies that are trying to do applications overseas. But let's see.
So ultimately, the benefit for us in the region in not being party to the Madrid Protocol is that companies or organizations will have to apply directly to us as individual countries to seek the requisite protections that they're after. And I guess we will benefit from the revenues that would need to be paid, or are there any other sorts of benefits or considerations?
So with the Madrid Protocol, there is a subvention, I suspect, which WIPO will make to JIPO, if, for argument's sake, as a hypothetical. So there is that same examination process in which the applications would be remitted to Jamaica or to any Caribbean country, and they would go through the same process. It's just that it would come through WIPO rather than a person making a direct application in Jamaica via a Jamaican agent. That being said, with Madrid Protocol or without Madrid Protocol, no, there is significant benefit to the country. I mean, the applications that come through here, as I said, 50% of the applications are now foreign applications. They do generate GCT for the country.
Yes.
And I'm not sure when we have done a cost-benefit analysis or really the comparison, whether the loss via GCT is worth us going to Madrid. There are also other concerns about brand Jamaica and how it may be affected. And here's why. Madrid Protocol requires the local offices to be up to a certain standard and up to par in terms of examination, meaning the review of applications. And JIPO is one of those good government offices, Jamaican government offices, in terms of examinations. In the Caribbean, JIPO, I think, the Jamaica Intellectual Property Office, its standard is pretty high. Its processes are pretty efficient. But at the same time, it leaves us under a threat, because if an application is not processed in time, it automatically enters the register. So it's an automatic application. And so what that means is that the people who are applying from overseas presumably can have an easier time getting their application through versus a Jamaican who would still use the local application process, right? Because a Jamaican then would still be subject to the objection process. And if there is something that goes wrong at JIPO, there's always a stopgap. There's always a gatekeeping mechanism. Whereas WIPO, in effort to get people to be efficient would say to Jaipur, you have to let it through, and any objections have to be post facto. So it stacks up against the local people. And, we have so many examples otherwise in the economy about that, or otherwise in law about, how sometimes the law seems to stack up against Jamaicans. I would hate for that to be the case here.
Understood. And again, now just pivoting back to just talking about intellectual property protection and the ICT tech space in the region. Ideally, what would you like to see happen within the next 3 to 5 years? How would you like that realm of IPP and tech to unfold in the region?
Well, our IP laws are not necessarily pro-innovation. I've always had that concern that we, as opposed to other countries, when you look at the EU, for instance, they have evolved their intellectual property laws and harmonized them to be very pro-innovation. We have not done so. Here's an example. In the UK and in other European Union countries, there is an exception to copyright infringement where you're doing almost reverse engineering. So you have software and somebody wants to build on top of that software. The person has a permission under copyright laws to do that sort of reverse engineering. Our copyright laws in Jamaica have not even contemplated that, So those are little things which are not really pro-innovation. There's another area which I think we need to look on, but, it's very, very contentious. In respect of work for hire, under Jamaican laws, once you create a work, like if you're an employee, it's your work unless you can show, an agreement to the contrary. And the agreement can be in writing or not. But, if you don't have it in writing, then the chances of you getting people to be convinced it's your work, it's harder. But that's one thing I think which is, sorry.
I was just going to ask, so when you say work for hire, what do you mean? Like if somehow you created something or a product or...
In other jurisdictions, there is an assumption or presumption rather that if you commission somebody to do work, you as a commissioner is the owner of the work. Jamaica doesn't have that. In fact, we don't even have that for employees. And you remember the Grace Kennedy case in which that came up to an extent. No, Grace Kennedy and Paymaster rather. Now, in Jamaica, what this means is that there are lots of people who are commissioning work who may forget to ask for the work to be vested in them or the intellectual property to be vested in them. And so they may be leaving themselves exposed. And from my understanding, it was done on purpose that we do not have this work for hire provision, that the person who creates the work is their work, because we wanted to make sure that the little man was protected. I think times have changed now because we now have situations in which the little man is now a startup. The little man may be employing other little men. And so startups which are not as savvy at the beginning in terms of intellectual property laws are left a little bit exposed. So the commercial context has changed. And to some extent, I think the commercial context in respect of work for hire is anti-startups.
Understood. So question, when you said the person who commissioned the work does not have the work vested in them, how would they do that?
So they would do that by having an agreement beforehand in which they say to the individual doing the work for them, when you create this work, the work will be mine.
Okay. And can you just briefly share with us the Grace Kennedy Paymaster situation?
So the Paymaster situation, it evolved into many other issues, but the primary thing is that there was someone who was contracted by Paymaster to do certain work, and they didn't really have an agreement regarding the ownership of the work. But that same commissioned person, the contractor, went to their competitor rather, which was Grace Kennedy, and did the work for them. And there was really, essentially, the court is saying there was really nothing preventing that sort of arrangement with Grace Kennedy, because Paymaster had not created any proprietary rights in the product which they had commissioned this contractor to do, and so it had no protection. And I'm guessing that at the time Paymaster may have been considered a startup, which is why I say that it's anti-startup. But at the same time, the law may want to protect the contractor. The law may want to say the contractor should not be bound or should not be restricted in terms of who he thinks his creativity should be assigned to or be to the benefit of. So, the law is something which it may benefit some individuals in that scenario, or different sides in that scenario. But I wish it were something that, for innovation purposes, I wish it were something that we would discuss a little bit more and do a bit of a study on to see whether it is obtaining the benefits that we thought it would obtain.
Definitely. So just going back to this question about what would you like to see with respect to IP, intellectual property protection and the tech space. I guess you probably looking at legislative changes in respect of probably being more pro-innovation. Is there anything else?
No, not really. I mean, we can modernize our laws a bit. Patent Act may need some modernization. We do have drafts on hand. Designs law too. We may need to modernize them a bit. I think Caribbean people are becoming more aware. So I used to say public education, but I'm not even sure if that's the case now. I just think our policy needs to keep a step with tech changes so that changes can be made to the laws as those changes occur.
Definitely. Grace, I think that's my last question.
Great.
Thank you so much.
No problem. It was a pleasure being on this podcast yet again.
That's it for today's episode. Thank you so much for listening to the ICT Pulse podcast. You can find links to some of the things we talked about on our website, ict-pulse.com. If you like this episode, please show your support by leaving us a review on iTunes, as it will help others find the show. You can email us at info@ict-pulse.com or drop us a note on our Facebook page, facebook.com/ICTPulse, or via Twitter @ICTPulse. We hope you'll join us again for our next episode. Take care.